living annuities and the accrual on divorce. So in one of the first webinars where we were referring to living annuities, I had a very simple explanation of living annuities, which I am going to repeat here, just so that as we go along, we understand why certain decisions have been made and whether we actually even agree with it. So when we are in a retirement fund, pre-retirement age, when we're in a retirement fund, which also strangely enough does include a provident fund, because a provident fund, even though at this stage you can still access 100% of the capital, you are allowed to transfer some of it. We're not limited to 1/3, 2/3. You can transfer any percentage that you want of that capital, be it total, be it 50%, totally up to you. And we can move it into what we call a compulsory. Now, from an income tax perspective, that definition compulsory has been done away with and is now called a qualifying annuity. That is specifically taking into account that a provident fund can also be invested in this qualifying annuity. However, though, in reality, the insurance companies are still calling this a compulsory annuity because you have no choice to go into it. So when I talk about a compulsory annuity, I'm specifically talking about the product name, but the income tax does make reference to a qualifying annuity. So when this is transferred, and I'm going to stick to the retirement pension fund type thing. When this is transferred, of course, we can take the 1/3 in cash, but the 2/3 have to be invested. So this capital amount that comes through has to go into a living annuity, and then the responsibility, if I can call it that, of this capital that is there is to actually provide an annuity. So that's the purpose of this capital, is to provide an annuity. And these definitions, of course, are held in the Income Tax Act. Now, this annuity comes out of the pension fund. So from a pension perspective, the Pension Fund Act does not, well, rather, let's take a step back. The Pension Fund Act applies totally to the retirement fund while the member is in that retirement fund. When this is moved into this annuity, it comes into, it falls all of a sudden as part of the life insurer platform, which means that it is a long-term insurance act that now applies. Although I think GN 18, if I'm not mistaken, which we'll go look at in a sec, does still in a way apply some form of protection against creditors, which is section 37A and B, that does make reference to the fact that this annuity, the capital amount, cannot be attached, cannot be hypothecated, cannot be ceded, etc., to any other, because it doesn't necessarily belong to the member. This annuity pays out an annuity amount, which is decided, it's decided by the annuitant. On an annual basis, the annuitant can decide the percentage that they want to withdraw, of course, within a parameter. The annuity can obviously make various other decisions, which we're going to look at the sec. So this is the mechanism of what the whole living annuity is about. The court case that arose here originally and still is Montanari versus Montanari, pronounced, I suppose, in many other ways. And that went to the High Court first. And what the issue was here was a couple that was divorcing, and they were obviously married with the accrual system applicable to their marriage. The accrual system, of course, you'll know that what happens there is that, and this is for particular reasons, of course, is that the growth of assets, everything that's been accumulated during the subsistence of the marriage, should be shared amongst the spouses, not necessarily equally, because that accrual valuation actually depends on the assets we have, less the deductions, etc. Then there's a sharing calculation at the end. On divorce, while the member spouse is still a member of a retirement fund, the accrual valuation includes the value of that retirement fund. So if I'm still a member of a pension fund, the Divorce Act, which we're also going to look at, I'm just giving you a summary here. The Divorce Act, Section 7 of the Divorce Act specifically then says that the pension interest forms part of the valuation for accrual. It doesn't form part in terms of death. I'm going to mention death every now and again because towards the end, I want us to think a little bit about what should happen from a death perspective. So on divorce, members' interest, according to Section 7 of the Divorce Act, says thou shalt include pension interest for a accrual purpose. But that Divorce Act, of course, does not encompass a living annuity. So what was decided by the High Court was that the capital amount does not form part of the accrual calculation. The annuity that received also didn't form part of the accrual calculation, but could be claimed in terms of maintenance. When that went to the Supreme Court of Appeal, that judgment was overturned based on some of the other principles that was brought in by the actual court, what was considered. And they, although they also agreed that the capital component was not necessarily part of the accrual, they felt that the annuity that had been paid out should form part of the accrual and not from a maintenance perspective. So let's go look at how these decisions were made. So in the High Court, the decision in the High Court was that the living annuity did not form part of the estate, not part of the joint estate from an accrual perspective, and therefore not part of the valuation. That the non-annuitant, so obviously the non-member of this living annuity, only had the right to the income from the living annuity, but only as and when it was paid. So it's not as if we could capitalize all the future life annuity. It was basically in the month of May, 10,000 Rand would get paid. By all means, please have a maintenance order against that 10,000, and that was the only right. That the High Court decided that and this happened to be husband was the member and the wife was the non-member, and they felt that this is all the wife could attach via a maintenance claim. But now let's just look at what is the purpose, like I said earlier on, what is the purpose of this accrual? Why do we get married with the accrual applicable to our marriage? Is so that firstly, we can decide up front if we do have any assets, which of those assets we feel should go into the sharing of our joint pot. I call it a joint pot, even though they're not married in community of property, but they are out of community property as such. And the accrual is really just to share what happens while we are married. So I can decide up front what I want to bring into this joint pot and what I want to exclude. But fairly, while we are working together in maintaining this marriage, you could have a spouse who might not be in the position to accumulate as much assets, can't think of another word, or as many assets as the other spouse, but they are both contributing, be it financially or any other way, towards the subsistence of this marriage, towards the growth of this marriage. And rightfully, when there is some form of termination, be it as a result of a divorce or as a result of death, they would share in this. So the problem now becomes, and this has been triggered off by a lot of financial advisors, and I'm going to explain. While I am a member of this retirement fund, I have this pension interest in the Divorce Act. And that Divorce Act says that the non-member is allowed to consider the pension interest Of course, a divorce order, divorce decree has to be made in terms of the claim that is allowed. But the Divorce Act allows it, and then Section 37D of the Pension Fund Act then goes and enforces the fact that as a result of a divorce decree, you can actually attach a pension interest and a deduction is allowed. The thing is this: if a divorce is pending, okay, so, and this is generally what happens, if the member spouse of a retirement fund is aware that they are about to get divorced, someone comes along and says, if you get divorced, do you know that your spouse can attach your fund? It's part of the accrual. It's part of the accrual valuation. It doesn't always mean that a claim will be lodged against the pension fund for a pension interest. It doesn't always mean that. If the spouse can settle that accrual claim, then there may be no reason to go to the pension interest at all to claim to lodge a claim. But more often than not, the member's spouse is actually unable to settle the claim. This is very important. More often than not, the member spouse is unable to settle an accrual claim, especially on divorce, and therefore an attachment is made on the pension interest. But the accrual valuation, as mentioned earlier on, specifically allows a claim or a valuation of the pension interest of a retirement fund. To prevent my spouse from attaching it and taking all my assets, because you must remember, a retirement fund could potentially be the greater asset that we have in our estate. So to prevent that, what do? Clearly, I have to be the age of 55. And more often than not, we don't even retire at the age of 55. So we're still members of a fund. So to prevent my spouse from taking away the greatest asset that I perhaps have, what I do is I move it into a living annuity. Because once it's inside a living annuity, it is protected from attachment. It's protected. Section 37A, 37B. So now all of a sudden the one spouse is prejudiced because we have basically, in this sharing, we have basically removed the greatest asset because it's now in the living annuity. But think about this. How often do you not find that a spouse, irrespective of how they are married, a spouse might not be working or might be working half a day? I'm trying to think of a word that sort of explains that you probably have one spouse that is the breadwinner because they have the better job, the higher paying job. They are responsible for looking after the family, where you have the other spouse, which is generally the wife, who doesn't have such a high paying, such a high profile job because they require the time to look after the family. So, of course, the majority of the income, which also comes from this joint pot, goes into the member's retirement fund, which I think correctly the other spouse should have a share because they've also worked towards this marriage. Maybe not financial contribution, 100% of that or 90% of that, even 50% of that, but they have worked towards this fruits in the marriage that they should share. But if there's a member spouse decides, I don't care, I don't want you to attach it, we move it into a living annuity, which means there is very little to share between spouses. Now, how fair is that? Now, that is the type of advice that is being given to clients out there. Don't allow your spouse to take your pension fund, move it into a living annuity, and then she's got nothing to claim. Is that fair? And is that ethical? It's something I've questioned for a very long time. And I've challenged a lot of financial planners to say, is it fair that you knowingly know that you are making a recommendation where you are placing one of the spouses of this 20, 30-year-old marriage in such a disadvantaged situation that they are left with nothing or very little. Is it ethical to do that? If it is the clients themselves that do this, well then fine, because when you divorce, all of a sudden, after 30 years of loving one another, when you divorce, you just hate one another and you really want to be nasty to the next one. But the spouses don't always know these rules. So they will only know that a living annuity cannot be attached if someone tells them, I'm going to stay away from a financial planner. Financial planners just not only just financial planners as we know. There are many planners out there, lawyers, you even have accountants, tax people. There are many planners. And to me, it's like, stay away, I think, from unethical advice. My opinion only. So we are saying that once it comes out of a retirement fund and goes into a living annuity, that the annuitant has very little say, or rather has no right to the capital. And there's lots of arguments on why there is no right to the capital. And that's because it forms part of the life insurance balance sheet. It's because definitions specifically say that the annuitant only has a right to an annuity. Now, in this particular case, they brought in a lot of witnesses, some of them experts in the field in terms of retirement funds, some of them are skilled financial advisors. So a lot of skilled people were brought into this whole case to obviously give their say of how they feel. But there was a majority consensus that the capital was sort of in a way forfeited to the insurer. And I'm using words that were not necessarily used in the court case, but just to explain. And the only thing that was created was a right. The annuitant had a right to this capital. But strangely enough, the annuitant was still allowed to have quite a say in terms of that capital amount. So the annuitant could decide the investment funds. The annuitant was not guaranteed of the income that he would receive of this funds because he was responsible to decide how it was going to be invested. And if it was not well invested, or if there was no particular growth, then of course the annuity that he had a right to would diminish. And that was not the responsibility of the insurer. The insurer would only hold the capital. But what comes out of the capital was really the annuitant's responsibility. The annuitant could also decide to draw down the percentage he wanted. And this one to me is a very interesting one. Of course, he could nominate beneficiaries. So let's just stop here, because this is going to go into much later when I want us to consider certain things. The annuitant has the right to nominate a beneficiary on his death to receive the capital. So I do have a say in this capital, albeit only be when I die. The beneficiaries can opt. Beneficiaries can decide either to continue with the annuity or to commute 100% of the capital that's available at the time of death, or to take part annuity or to take part lump sum. Then, if the annuitant happened not to nominate a beneficiary, then the capital amount forms part of the annuitant's estate. Interesting, hey? While I'm alive, I have no right, but I can nominate that right to capital to a beneficiary. If I don't, it goes to my estate. If it goes to my estate, accrual valuation on death. Also, the other interesting thing is that ideally for an annuity to continue, we should be nominating a natural person. So if I nominate a trust, for instance, to receive this amount to generate an annuity for the beneficiaries, we can't do that. What has to happen is the amount has to be commuted and then transferred into the trust for the trust to then buy an annuity, but not necessarily a living annuity, potentially a voluntary annuity. So even though someone else is getting this money, it still has to be commuted, which means that is it not part of the estate? So let's just consider that for a little later. Although this argument about what the annuitant can and cannot do in terms of the capital was obviously raised in these court cases. But of course, that income tax, like I said earlier on, did limit the access to the capital, in that the annuitant only had a right to the annuity of this capital, which is owned by the insurer. There were lots of other arguments about whether the capital was not held in a trust, because in reality, the contract with the insurer was Yas capital, which the insurer had to administrate on behalf of beneficiaries, which does sound as a third-party contract, which also does sound as a trust being held. As mentioned earlier, General Notice 18 to the Pension Fund Act, also as part of the Income Tax Act, does go and protect that capital so that it cannot actually be touched, cannot be commuted. So that sort of lends itself to the fact that the capital amount itself can never be enjoyed by the annuitant while the annuitant is alive. While when he's dead, then he cannot enjoy it anyway, but his beneficiaries can. And this is where the High Court then made the decision that the non-member spouse could only have access to the income, but only if she gets a maintenance claim against that income, so that there would be nothing part of the accrual valuation, which would actually give her a far greater claim than, every single month I will get a little bit of this 10,000 Rand. Now remember, the difficulty here, clearly what's going to happen, if the annuitant, if the member of the fund only transferred the money into a living annuity so that the spouse could not claim, that could possibly mean that the annuitant does not need income. So to ensure that the attachment of a maintenance claim on the annuity that pays out on a monthly basis, would I not then ensure that I only have 2.5%? Why would I want to claim 17.5% drawdown when I know that my spouse will have a maintenance claim on that 17.5%, which clearly is going to be a far higher rate? Why not just draw 2.5%? Because then my 2.5% might only equate to 1,000 Rand a month. So again, I'm being unethical. Or again, I understand the spouse doing this, because like I said earlier on, the spouses now all of a sudden hate one another. But this whole decision-making process is totally unethical to me. So that's where we stand at with the High Court. So this thing was obviously taken to the Supreme Court of Appeal. And the Supreme Court of Appeal looked at many other cases. And with many other cases, it was decided at the end that, yes, we understand that the spouse, the non-annuitant, non-member, belonged to the insurer, and that the annuitant, while alive, had no rights to the capital amount. So that was confirmed. Okay. Therefore, the non-annuitant could not claim the capital of the living annuity. But the question now remained in terms of the right. What claim did she have to the right of the annuity that would pay out to the annuitant? What right did she have there? Would it be a right that would form part of the accrual valuation, or would the right, as per the judgment of the High Court, only to a maintenance order? Which one would we be looking at? So they looked at a couple of cases, which let me see, I did actually write down here. In making the actual full judgment, they relied on ST versus CT, where they said, why can the same principles not apply to this particular case, Montanari versus Montanari? And they ruled that the High Court did not make the right judgment by only allowing a maintenance claim against the monthly annuity. And it ruled, the High Court ruled, that what they should be doing is looking at the future annuities of the right to the annuitant. So let me just put that back. If the annuitant has the right to an annuity of a capital amount invested, what should happen is there should be a calculation, some form of valuation of the future annuities that the annuitant will receive. And it's that capitalized amount that must go into the accrual valuation and not necessarily a maintenance claim. So let's just go take a look at what happened with ST versus CT. Notice that I am obviously summarizing these judgments, and I think I have attached the full case on the platform. So those of you who are interested, by all means, please go through the whole 20-something pages. Very, very interesting. A lot of things have been brought out as a result of this court case. I am just summarizing it. So in CT versus CT, the judge said the capital value cannot be included. The only rights was the annuitant, the annuity in amount selected by him. So the annuitant actually could not claim the capital amount. The annuitant only had rights to the annuity that was paid out. So yeah, again, remember, it was just confirmed that we can't go into the capital. We can't touch the capital, which is fine. But the annuitant did have the right to the annuity that would be paid out of this capital, of which he actually had, in a way, a say. Even though it belonged to the insurer, I still had a say what I could draw, where it was invested, and who it would go to in terms of my death. In the Koch versus Jacobson, the question here then remained whether the right to the pension was part of the community of property. It was in community of property in particular, this case. And the judge said, I therefore, to my mind, see no reason in the principle why the accrued right to the pension should not form part of the property existing between both parties. So yes, look at this. While we are married and this member is receiving a pension fund, there is no debate that that pension fund, not the pension fund, the pension income, the annuity, does not form part of the joint estate. They would be sharing in that annuity while alive. My apologies, while they're married, while they're alive, because maybe we're on divorce, they would kill one another, but that would form part. That would form part. Now, why all of a sudden on divorce, we are debating that the non-annuitant cannot touch? Why? So de Kock said yes. The court concluded there was no logical or legal reason why both the cash component and the accrued right to the pension should not form part. So let's leave the cash component. But the accrued right to the pension, why is that not part of the accrual? Because they had that right before they got married. Now, in the de Kock versus Jacobson case, the courts there also relied on other court cases, the Clark versus Clark. And here the court accepted that a spouse's interest in the pension, which had yet not accrued, did indeed form part of the community, as did a pension right which had accrued. So not only the pension interest would form part of the accrual, but so did the right to that pension that had been paid out. In this case, Commissioner versus Nolan's estate, it reaffirmed that the right to a pension is a right which vests in the parties to a marriage in community of property in undivided shares. Now, the fact that these cases could have been in community of property does not detract from the fact that the principles would remain the same irrespective of how we married. Of course, if I'm married without the accrual, not even the Matrimonial Property Act, nor the Divorce Act, then allows any form of claim against a pension fund, because that is the patrimonial consequences of the marriage that you have selected. What is mine is mine, what's yours is yours, you do not touch it. Maybe a maintenance claim, but one factor in here. But if I'm married in community property with or without or with the accrual, why does it also not vest? Why can it not be shared between spouses? They can, well, they do, well, when they're married. Why does it then not form part of the actual accrual? So in the Supreme Court of Appeal, and I know a lot of people are saying it'll be interesting to see how this actually takes place, but in this Supreme Court of Appeal, the ruling was that yes, the capital that sits in here, we cannot touch. It cannot be commuted, cannot be ceded, etc. But there is a right that is provided to the annuitant, and that right is the annuity to this capital. How long it lasts, what the amount of the annuity is, all depends on the annuitant, because the annuitant has a say on how that capital in a way is actually maintained. As a matter of fact, it even goes further to state that, of course, if it is below a certain amount, then a annuitant can cash it in totally. And you saw from the drawdown that it's still a draft, but we're looking at anything below 125,000 in terms of the capital available in the annuity that the annuitant can then cash in. But the annuitant has the right to all those annuities. And as a result of this right, they ruled that from an accrual perspective, that right forms part of the estate for accrual valuation. And the way to do this is to actually capitalize, so put a value to the future annuities that will be received by the annuitant. So some actuary is going to have to put some form of value to these future annuities. How that is going to work, how that method is going to be calculated, will be interesting to see, because you must remember, one of the things that we're going to have to take into account is the fact that the annuitant can go anything from 2.5 to 17.5. So do we take an average that can be drawn? Remember that the 2.5 to 17.5 in terms of value relies a lot on the value of the capital amount. So if we take a look at what's happening at the moment, that capital amount has just dropped totally, way beyond the scale. So now, a few years ago, we would have valued it at a particular growth and at a particular percentage. But all of a sudden there's a drop. So how they're going to value this will be very interesting to see. Well, definitely going to happen in Montanari versus Montanari. So let's see how that valuation is going to take place. So that is the judgment in this court case, which, you know, in a way, it pleases me, because it now stops the type of advice being given to please retire from your retirement funds, go hide your money in a living annuity, because now your spouse all of a sudden can't claim it. No more such advice, because that pension, the right to those annuities, now form part of the accrual. And remember, if it forms part of the accrual, it forms part of in community of property as well. Definitely. Principles remain the same. But these are the things I'd like us to consider. For an accrual calculation, accrual valuation, you must remember we are not attaching the assets at all. So whatever goes in for a valuation purpose is not the asset, but the value of that asset. Very interesting, because we tend to get very confused with this, in that if there's a divorce and the one spouse, for instance, has direct shareholding in a company, It's only the value of those shares that come in. This spouse here does not have a right to half of those shares. Not at all. It's just a value to determine a claim. Who can actually lodge that claim and what value that person can claim. Right? So this annuity is also not cash in this estate. So I can't go to the assurer and say to the assurer, I want out of the capital amount, I want 1 million rand because that is the future value of all these annuities. Now you can't do that. It's just that that 1 million rand is now forms part of valuation. At the end of the day, once all this is calculated, let us assume for the purpose of this explanation, let us assume that the only asset in the annuitant's estate, the only asset in the annuitant's estate is the future value of these annuities, or rather is this living annuity. That's all he has. He has no other assets, or maybe any of the other assets are so minute in terms of value that it becomes irrelevant. So here sits the annuitant and here sits the non-annuitant. And just for the ease of this exercise, we're going to say that the non-annuitant has no assets. The courts have decided that as a result of the valuation made, that the value of future annuities, let's say, is a 5 million rand. From the accrual calculation, we take the greater less the smaller, divide that by 2, and we have 2.5 million, which is now going to be claimed by the non-annuitant. This non-annuitant says to the annuitant, you have to settle 2.5. How you settle it, I don't care. There clearly is no pension interest that I can lodge a claim against via a divorce decree. There is this living annuity which capital cannot be touched. So this annuitant cannot go to the insurer and say, please will you pay out 2.5 to settle this accrual claim? No, sirree, you cannot do that. So now all of a sudden this annuitant has to find 2.5 million to pay the non-annuitant. And if all he has is this assets sitting in this living annuity, or some assets that can now not settle 2.5, where will they get the money from? Advisors, financial planners out there, now start realizing the impact of your advice. You place money in this living annuity to hide it from the spouse. The spouse now has the right, in terms of purpose of accrual valuation, to ask for a settlement of a claim where the annuitant might not have cash to settle. For a death purpose, that's fine, I'll put in life insurance. For a divorce, that's a problem, because where am I going to get 2.5? That means I'm going to have to potentially sell all my assets to settle that claim, and then I might not even be able to settle that claim. This is a problem. I do agree with the court case. I do agree, because we've been trying to hide money and we can no longer do that. But at the same time, my concern is, where do we actually get that money from? So that's concern number one that I'd like to consider. Then my mind goes, I understand that from a death perspective. So I know the heading says divorce, but let's look at death perspective. The only thing that forms part of the accrual is any income already received that might still exist. So if over the years I've been receiving 100,000 every year in terms of my annuity, and I haven't used it all, and I've managed to save 50,000 every year, it's this saving that I've received that that I've saved that forms part of my accrual calculation and nothing else. Now let's think like this. This is my mind that thinks like this. And part of the Montanari case in the Supreme Court of Appeal, they actually made reference to more than one quote, but I've just put two here, where it says, in this South African law of husband and wife, it says, community of property. Notice it doesn't say in community of property, it's community of property, which includes the accrual, because during the subsistence, it is community of property, is a universal economic partnership of the spouses. All their assets and liabilities are merged in a joint estate in which both spouses, irrespective of the value of their financial contribution, hold equal shares. And that's true. That's true. I've been making reference to that. But it says all the assets. Would all the assets not be not only the annuities that have paid out, but take the principles of the cases we've just been speaking about? What about the future annuities? Now, of course, you may argue this and you say, but on death, the spouse will have the choice of commuting or taking the annuity. So what's the problem? Well, I'll tell you what the problem is. The annuitant may not always have the spouse as the beneficiary. The annuitant can also say 50% of this goes to my spouse, 50% goes to somewhere else. Am I then not taking the 50% that goes to third parties and not to my spouse? Am I not then taking that away from the accrual that can be shared? Not? Yes. What if 100% of this is given to the children as beneficiaries? Am I not reducing my potential accrual claim? Here it goes and says, a spouse's salary falls within the community of property. The joint estate consists of all property and rights of the spouse, which belong to either of them at the time of marriage or which were acquired by either of them during the marriage. So all rights, and I have the right to those annuities, future annuities. So my mind is just going, could I not bring in that same principle that is applied from a divorce perspective into death? Well, we're going to have to wait and see, won't we? But my mind is saying that if that is the case, are we planning our estate planning? Is it going to cover these future annuities in the accrual calculation? I don't know. I don't know. Just a thought pattern. Thank you, ladies and gents. I hope that you enjoyed this particular accrual on divorce, because I always find it so interesting, some of these court cases. Thank you.